In the bail application brought in terms of Schedule 6 of the Criminal Procedure Act, the onus rests on the applicant to satisfy the court on a balance of probabilities that exceptional circumstances exist which in the interests of justice justify his release. Having evaluated the evidence, the court finds the applicant has failed to demonstrate that he does not pose a flight risk. The applicant has failed to dispel the risk of interference with state witnesses and obstruction of justice. The nature and seriousness of the offences demonstrate a clear danger to the safety of the community. The state's case viewed at this stage cannot be described as weak. In the light of these findings, the court is not persuaded and satisfied that the applicant has established exceptional circumstances which in the interests of justice permits his release on bail. The application for bail is accordingly refused.
Let's just shoot her, guys.
Yeah, let's move this way, guys.
Yes.
We welcome the judgment as the NPA. It is one that proves that the collaborative efforts of the criminal justice system are bearing fruits. We have provided an avalanche of evidence to substantiate our claims as the NPA in terms of convincing the court that the accused is not a suitable candidate to be released on bail. We have substantiated such allegations with evidential material, amongst them proving that he has an illegal ID from Eswatini and therefore is a flight risk. He has business interests abroad, and as well as the fact that he's a danger to society. And with every allegation that we brought before court, we're able to substantiate with evidence, though the burden was not on the state to convince the court, because we recall that in bail application processes, the evidentiary burden lies with the accused. He's the one who's supposed to convince the court on a balance of probabilities that indeed the interest of justice does permit his release on bail. For Matlala, it was even at a higher test because he had to prove the existence of exceptional circumstances that warrants his release on bail. So we are satisfied with the court's decision. We continue our work as the criminal justice system, working collaboratively with the South African Police Service, the Hawks, and we will also do our best to ensure that our witnesses are protected, because we have raised concerns about the safety of our witnesses as well in court, the interference, the likelihood that the accused, if he was released on bail, would have interfered with our witnesses. So as the interest of justice dictates, he must remain in custody until he's dealt with in accordance with the law.
All right. And any likelihood of an appeal? Are you ready?
Well, the accused did not indicate whether they would like to approach the High Court for it to review the decision of the magistrate that denied him bail. However, as the state, we are forever ready. We have presented an amicable, we have presented a formidable argument in court, and with that going forward, we believe that we will be ready to oppose such an application should he decide to take that route.
And prosecutors got a bit of a thumbs up, or the state got a bit of a thumbs up from the court, with the court saying that it cannot be said that your case is weak or without merit. What's your response to that?
Well, as I've said, the accused before court tried in vain to portray a picture that the investigation process is tainted, that the investigators are targeting him. However, as the state were able to disprove such allegations, and we countered it with the necessary evidence. So we're able to place evidence to prove to the court that his allegations that there is corruption going on, the investigators are targeting him, was just a lie.
What other measures are you going to put in